Welcome to literary and jury charge practice. Let's start with a little jury charge warm-up. Ready? Here we go. My mama always said, never mind the pennies. The dollars will take care of themselves. That same principle, I believe, applies in so many parts of our life, and it includes trials. If you watch out for the little rules, decide right now you're not going to violate them. You might ask, what is the harm if I tell my wife or tell my boss something about this case? Well, I don't want to talk about any specific scenarios that may arise. I'm just telling you, if you just follow the rules, it will make it much more likely that we are going to have a result that at the end of this trial, everyone is going to be satisfied with. You know, this is a business. It's not like a compromise. A trial is where people come together and they have a significant disagreement, and the stakes are high on both sides, especially in a case like this one. So when this trial is over, one side is going to walk out of this courtroom feeling like they have won, and the other side is going to feel like they have lost. I have a goal in every trial that I do. I don't know that I always succeed. I don't know that I'm always going to. But my goal is that when people leave my courtroom, they feel like they have had a fair shake, feel like they had a fair trial. I can only do that if you'll be my partner and inspire to having a result that we can all feel proud of and all feel that justice was served. When the trial has ended, by the way, and you've been released as jurors, you may discuss the case with anyone. You'll be given notebooks and you may take notes during the trial. Do not remove them from the courtroom. You may take your notes into the jury room during deliberations. I do not mean to discourage you from taking notes, but here are some points to consider if you do. 1. Note-taking may tend to distract you. It may affect your ability to listen carefully to all the testimony and to watch the witnesses as they testify. And 2, the notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. At the end of the trial, your notes will be collected and destroyed. All right, now let's get back to this article called Crack the Code to pass the test. Ready? Here we go. Here I offer some tips to successfully crack your code. Tips I've used to coach many in your busy shoes. Nutrition code tips. Consciously focus on your blood sugar level with smart eating and snacking. Vitamins are essential to prepare physical and mental compass for charting of your code. Carbohydrates create long-term energy, while pasta and rice ensure that your body functions at peak performance. Proteins create short-term energy, and if you balance carbohydrates and proteins, you're in athletic training. Hydrate yourself with water and perhaps green tea or Gatorade type drinks. Sodas taste good, but many cause dehydration because of additives and sugar. Stress contributes to depleting fluids, so avoid dehydrating your body. Instead, drink water and other helpful fluids. Body, toes, and fingertips code tips. Wear comfortable clothes and footwear. This awareness tip should be incorporated into your daily routine, especially when preparing for a test. If you are taking a machine portion of any test, your fingertips, nails must function at peak performance. Many students and reporters have manicures. Now is not the time to test a new length or style. Use what works best for you. Radar code tips. As you move closer to your scheduled test, you should specifically notice your energy awareness. Code cracking includes becoming aware that you may now be more sensitive at work and school, with family and yourself. Some term this as cranky, but I prefer sensitive, which is normal. Once you are aware that this energy is part of your preparation, you can acknowledge it and let these test prep code tips work for you. I know you can learn a lot about yourself as you hone and fine-tune your radar, your sensitivity meter. Inspiration code tips. Take time for you. When was the last time you listened to a favorite CD? Is there a movie that inspires you? Have you laughed recently? When we focus on a long-term goal, I firmly believe that it is the little moments, note it's plural, in our world wherein we most effectively gain momentum toward our goal. Common sense code tips. Pack equipment and you before the test. Avoid gassing the car en route. Make sure that there is no construction near the site. You should be packed by mid-afternoon the day before, which reduces the questions like, where did I put? Alrighty, let's get back to some jury charge. Ready? Here we go. I will now explain the presumption of innocence and the people's burden of proof. The defendant has pleaded not guilty to the charge. The fact a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt unless I specifically tell you otherwise. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received through the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he's entitled to an acquittal, and you must find him not guilty. You must decide what the facts are in this case. You must use only the evidence that is presented in the courtroom. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The fact that the defendant was arrested, charged with a crime, or brought to trial is not evidence of guilt. Excuse me. All right, let's get back to our literary. And this article is called Ruminations on Reporting. And it's actually from a little while back. It says the following is adapted from a speech given at the Delaware Court Reporters Association Convention in June 2008. Ready? Here we go. Good afternoon, and thank you for the opportunity to be here today. I'm certainly aware that most of you have spent the whole day, indeed your whole careers, listening to lawyers drone on. So I'll try to be brief and maybe even relevant. When Neith Ecker, RDR, CRR, who helped plan the convention, called to ask me to speak, my first question was, about what? To my surprise, she said that having been raised in a reporting family and having worked in a reporting office, I should choose my topic. when I pressed to make sure that she was really serious and not just being kind, she stuck to her guns. So here goes. I want to spend a few moments with you today talking about the profession, the challenges before it, and one observer's views on its future. While I am a practicing lawyer and have had the privilege of litigating for the past 25 years in the courts of this state, my perspective is a bit wider than the typical lawyer. That difference in perspective comes from having had a father and a grandfather who both made their living in the court reporting field, as well as having not one but two uncles and one cousin who did or do so as well. To be a bit more specific, I grew up with a dad who made his living as an official reporter in media, an uncle who made his living as an official reporter in the Delaware Court of Chancery, an uncle who made his living as an official reporter in the media courts, a granddad who opened one of the first freelance reporting firms in the city of Philadelphia, and a cousin who opened one of the first in Wilmington. To say that reporting is in my blood is perhaps a bit presumptuous, but I can say that for almost all of the time that I can recall as a child and then a young adult, the work of running the freelance reporting firm that my dad and eventually my mom came to run dominated the discussion at the dinner table each and every night. I can also say that it was almost inevitable that I should wind up working at that firm, first during high school summers, then through college, and even occasionally into law school. All right, we will get back to that. Find out why he became an attorney instead of a court reporter. All right, let's try some more jury charge practice. Ready? Here we go. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys will discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they helped you understand the witnesses' answers. Do not assume that something is true just because an attorney asks a question that suggests it is true. During the trial, the attorneys may object to questions asked of a witness. I will rule on the objections according to the law. If I sustain an objection, the witness will not be permitted to answer, and you must ignore the question. If the witness does not answer, do not guess what the answer might have been or why I ruled as I did. If I order testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything you see or hear when the court is not in session, even if it is said or done by one of the parties or witnesses. All right, that will conclude our literary and jury charge practice.